Good afternoon, everyone. Welcome to this 39 Essex Chambers webinar looking at systemic challenges in public law cases and focusing on both the legal and practical issues that arise in those cases. I'm Steve Broach, and I'm joined today by two of my colleagues from Chambers, Holborn and Katherine Barnes. And we're also very pleased to have with us Carla Clarke from the Child Poverty Action Group, who's going to share her experience of running these kinds of cases. So the first thing to do is a little bit of housekeeping. We do have a large number of people attending today's webinar, which is great. Please do ask any questions that you have on the Q&A at the bottom of your screen. I'm sure most people are now well familiar with how to ask questions on Zoom, but yes, we would ask that you use the Q&A for questions, and feel free to fire them in at any time. We're each going to speak for roughly 10 minutes and then take one or two questions on our particular topics before we take a more general discussion session at the end of the webinar. And if you have any issues with any technology or anything else, please can you email the organisers on the joining instructions that you will have received. The session is being recorded and will be on the 39 Essex Chambers website tomorrow, we hope, and the slides will be circulated as well. So without further ado, I'm going to seek to share my slides, and there we go. And I'm going to start the session by discussing the legal test that we might apply in systemic challenge cases. And I'm going to do it particularly by reference to the Court of Appeal's relatively recent judgment, 1st of December last year, in the case of ZK and Redbridge, in which I was instructed for the claimant in a first instance, but not in the appeal, and which two Chambers colleagues acted for the defendant local authority. And I suggested it's a very helpful synthesis, really, of the case law on the test for systemic challenges, particularly in the policy context. One of the points to raise, though, perhaps by way of introduction, is that when a question was asked at Mr. Justice Fordham's recent book launch for the Judicial Review Handbook with the Administrative Law Bar Association, most of the panel refused to answer the question about systemic challenges because no one knew what one was. And I do think it's an issue that gives rise to some disagreement as to what constitutes a systemic challenge. And so for today's purposes, we're really looking at the issue quite broadly. And in scope, really, is anything that isn't an individual case. So anything that isn't just about the decision-making in an individual case, but instead goes to the way that systems operate, whether those systems are driven and governed by law, for example, in the kinds of benefits cases that Carla routinely brings, or by policy, either national or local. And in this case, ZK and Redbridge, it was a local policy that was being challenged. And so the context for ZK was the local authority's approach to the provision of specialist teaching assistance for pupils who have a severe visual impairment, a low incidence special educational need. And in both the High Court and the Court of Appeal, the claim failed. What's quite interesting, I think, for our purposes about ZK is that there was no written policy for the claimant's challenge. The claim was really against the model of provision that was being used by the local authority, which was described as a decentralized model, where schools employed their own teaching assistants who received training from the local authority, as opposed to a centralized model where the local authority would employ the teaching assistants itself and then deploy them to schools. And the real grievance for ZK and her family was that under the decentralized model, it was said, there would be inevitable delays in getting the provision in place because of a need for each school individually to train up their own teaching assistants. That, of course, was not successful as an argument in either court, but that was really the motivation behind the claim. And what was said by way of grounds of the public law challenge included that the decentralized model was inconsistent with the duty to secure the provision in every child or young person's education, health or care plan, which is in section 42 of the Children and Families Act. So one of the key questions then for the court was this question of what test do we need to apply? And there was a great deal of contention about that at first instance. And what the Court of Appeal said was slightly contradictory, I'd suggest, about the test that Mr. Justice Swift at first instance ultimately did apply. The first description of the test that he said to have applied is whether the policy was capable of lawful application, that question to be assessed realistically and pragmatically. And that would seem to set quite a low bar for the local authority to get over. They'd simply have to show that their approach, their policy, was capable of lawful application. But the second formulation that the Court of Appeal used for the test was, I would suggest, rather more onerous or more challenging for public authorities. And this is paragraph 61 of the judgment, which is whether the arrangements in place gave rise to any inherent likelihood that the Redbridge would fail to comply with its Section 42 obligation. And I note in parentheses, it just seems to me that those are not the same thing, that those two tests are different. But it does seem it's the second of those formulations that the Court of Appeal itself then goes on to apply. And having said that there's no necessary difference between challenges that assert unfairness and challenges that assert illegality, the Court of Appeal told us that what matters in a systemic challenge of this kind is distinguishing between inherent failures in the systems challenged and individual examples of failings or unfairness, which don't touch on that system's integrity. In other words, they said, the court must distinguish between examples in the evidence which demonstrate a systemic problem from those which remain cases of individual operational or other failure. And when the Court of Appeal came to apply that the test to the facts of ZK in paragraph 65, it was said that in light of the evidence and the factual findings, the judge was amply entitled to conclude that Redbridge's arrangements were sufficient when considered at a systemic level and did not entail any inherent likelihood that Redbridge would fail to comply with its Section 42 obligations. So the test and the question, which it seems the Court of Appeal actually applied to the facts of the case before it, was whether or not the arrangements in place for provision of specialist support services for children with vision impairments gave rise to any inherent likelihood that there would be a failure to comply with the Section 42 obligations, or put the other way, that the answer was that they did not give rise to such inherent likelihood. So that seems to be the test that the Court of Appeal applied. But I would suggest that the overall feeling, the tenor of reading the Court of Appeal's judgment, is that they were somewhat frustrated by the nature of this debate about the exact wording of the test, and didn't seem to consider that this was a debate that was of great utility. The question essentially being whether or not the arrangements were lawful, whether they complied with the law, however that would be phrased. I would, though, suggest that it's also worth looking at the case of Humytsky, something along those lines. Apologies for the mispronunciation, which is the recent judgment from last year about immigration bail and accommodation. And in that case, the High Court expressed the test in a rather more familiar way from some of the older authorities as being whether the Secretary of State's policy created a real risk of unfairness in a significant number, that is, in more than a minimal number of cases. And so I'm afraid it's still not, it would seem, total clarity about the precise language of this test. But whether there's any meaningful difference between a real risk or any inherent likelihood is perhaps the answer to that might well be negative. I also think that there's some help in the Humytsky judgment on how you would demonstrate the test had been met, and that perhaps goes towards Catherine's part of the talk, which will be looking at evidence and evidential issues. And what was said in the High Court was that once it's demonstrated that there are legally significant categories of case where there is a real risk of procedural unfairness, the policy will be shown to be systemically unfair. In some cases, it may be possible to demonstrate that test is met by reference to the wording of the policy, and I think that's really important. So you might not need objective evidence, or certainly quantified evidence. It may just be obvious from the language of the policy or the document that you're challenging, or indeed in ZK we said at least, the practice was obviously unacceptably risky in terms of illegality. And so the cases show that systemic illegality can sometimes be demonstrated without reference to facts of a large number of different cases. But of course, if you have quantifiable evidence, that may well be useful as well. I'm sure Catherine will develop those thoughts shortly. And then the final point on the test that needs to be applied, I just wanted to flag up a question that I still have about whether there's a different approach that needs to be taken in human rights cases. And of course, Section 6 of the Human Rights Act makes it clear that public authorities must not act otherwise than in accordance with convention rights. And so in the case of Drexler, and this is from the first instance judgment of Mr. Justice Swift, where I acted for the claimant. We were challenging the post-16 school transport arrangements adopted by Leicestershire County Council and said that those arrangements in the policy were unlawful because they resulted in age and disability discrimination, contrary to Article 14 ECHR. And one of the grounds of defence was that the claim was premature because the specific impact of that policy, which had been adopted by the council on my client, wasn't yet known. There had been no final decision in my client's case. And Mr. Justice Swift rejected that ground of defence, although ultimately he did find, as did the Court of Appeal, that any discriminatory impact of the policy was justified. But on this point about prematurity, Mr. Justice Swift said that my client was entitled to challenge the policy itself and was entitled to contend that that policy was inconsistent with her convention rights. But when actually deciding the substantive claim, he would need to take account of the elements of flexibility within the policy, which he listed. But on the facts of that case, the possible range of those moving parts, as he described them, for example, the appeals process, wasn't such as to render it impossible to assess the legality of the policy against the claimant's discrimination claims. But what Mr. Justice Swift and indeed the Court of Appeal did in Drexler was decide whether or not the policy resulted in a human rights breach. They didn't ask a question in relation to real risk or inherent likelihood or any of the other formulations of the test we might have seen in the case law. And so a question that I'm left with then is do you have to show rather more in a case where you're alleging that a policy or an instrument or a system breaches people's human rights than you would do if you were alleging that it's unfair, procedurally unfair, or otherwise substantively unlawful? And if you do have to, why? Why should that be the case? So I'm ending my talk, not, I'm afraid, with an answer, but with a question, which it may hopefully prompt some discussion and may already indeed have given rise to some questions, we shall see. So I'll stop sharing my screen now. That's me. And I'll bring in Catherine, who I think is going to quiz me on behalf of the crowd, if the crowd have indeed asked any questions, Catherine, up till now.
Well, one thing, Steve, that I thought it would be interesting to ask you about, you end there by saying that potentially you have to show something slightly different, or maybe even more than slightly different in human rights cases. What, if anything, is the difference between policy challenges that are alleging systemic unlawfulness and systems challenges, where it's the system itself? Do you think that the test is effectively the same and it doesn't really matter, or actually in reality is the court much more comfortable with policy challenges and so they'll apply a less rigid test in that context?
I think ZK is a really good illustration of why the answer to that is that the test is the same, because there was no policy in ZK. It wasn't written down. We were challenging, strictly speaking, a practice. If you think about it in terms of discrimination terms, in terms of a PCP, it was a practice, a way in which the local authority organised the support services. We couldn't identify a document that contained the instruction to do things in a particular way. We couldn't say that the decision that we were challenging in that case was on page 353 of the bundle. It was a much broader, looser textured claim. And yet all of the policy case law was taken into account and in play. And essentially, I'd suggest all a policy really does is just write down your system. It describes your system. And so it's not obvious to me that there should be any difference in approach, really. Obviously, if the system is set down in legislation, then you've got a rather different series of considerations. Clearly, if it's in primary legislation, you're in real trouble, and all you're going to be going for is a declaration of incompatibility under the Human Rights Act. If it's in secondary legislation, of course, you can challenge it successfully, and I'm sure Carla will flag some instances of that later on. But I'm not convinced that the test should be different just because the system is described by or defined by regulations, for example, than if it's a system that emerges from a practice or a system that's described in a policy.
There's a few more questions. Shall I ask you one more now,
sure.
Steve, and we can pick up some more at the end? One of the questions you're being asked, which I think is quite interesting, is whether you think this is an effective approach where you want to challenge a decision that isn't to be implemented immediately.
Yes, I do. And that was, of course, one of the big issues in Drexler. And it's often the case, I think, in local authority cases where families, affected individuals get wind of a decision to adopt a new, for example, school transport policy. But in practice, the actual individual decisions made under that policy won't be taken for 9 months. And so if you wait until you've got your individual decision, you're really at risk of the defendant saying, well, you're out of time, you can't challenge the policy. The grounds of claim against the policy arose when we adopted it. Now, one way around that may be, of course, to correspond with the defendant, and they may agree that actually a claim should be brought later, but you've got to be careful because you can't extend time by consent in JR, as people will know. So the best you could get is the defendant agreeing not to take a point if you waited until an individual decision was taken. So really, I mean, thinking back, why was Drexler structured the way it was? That was a large part of the reason, was that we didn't feel able to wait for an individual case decision. We felt we had to challenge the policy by reference to its terms and say that in its own terms, it gave rise to discrimination. And I think that's one of the advantages of discrimination law, of course, both under the Convention and under the Equality Act, is what you're looking at is differential impact. You can, I think, show that often more straightforwardly in a policy challenge or a system challenge than you could, for example, argue a straightforward breach of Article 8. Because there, the court is going to be really concerned to know what actually happens in your own individual case. Whereas if the system is structured differently for different groups, or isn't structured differently for different groups, and therefore you've got potentially Claimant discrimination, the court can grapple with that, I think, rather more readily than a substantive Article 3, Article 8 claim. Great, thank you for jumping in and asking me those questions, Catherine. I think I now have to introduce you, don't I? That's the next part of the talk. So having set out what we think about the test, which I'm afraid is a little unconclusive, Catherine's now going to give a very helpful review, I can say that because I've read the slides, of the case of DMA and what it tells us about the way in which we should approach presenting evidence in systemic challenges. Over to you, Catherine.
Thanks, Steve. So I thought I'd begin by just setting the scene in DMA. Obviously, it was one of my cases, so I'm well embedded within it, but I appreciate that that won't be the case for everybody, far from it. So I want to first of all look at here we go. Look at the problem in that case, but also just introduce very briefly the legislative framework, because not everybody will be familiar with it, because not everybody practices in the area of asylum support. So in a nutshell, there's a statutory power that the Secretary of State has to provide destitute failed asylum seekers with accommodation and subsistence in certain limited circumstances, and in the usual way, that power becomes a duty where that support, that accommodation is needed to prevent a breach of Article 3. And I mean, to put it very crudely, effectively that duty applies where the failed asylum seeker is destitute, but also they have a good quote unquote reason for not being able to leave the UK and return to their home country. So for example, they might be too ill to travel or something like that. And the problem, so that all sounds fine in theory. The problem on the ground is that there are often very long delays between the Secretary of State making a decision in an individual case that the person is entitled to Section 4 accommodation, and then the accommodation actually being provided by one of the private accommodation providers with whom the Secretary of State contracts to fulfill this obligation. And so what happens in the meantime is that these exceptionally vulnerable individuals find themselves sleeping rough, or even if they're not actually street homeless, they'll be living a very precarious existence, sleeping in hallways, churches, relying on the goodwill of charities, and so on. And what happens for those people who are lucky enough to get access to a solicitor and to legal help, typically a pre-action letter is written, or an urgent judicial review is issued. And I've done lots of them myself. They all settle, almost all settle, either pre-issue or normally as soon as the claim is issued or as soon as interim relief is granted. So that's the context. My solicitors, Dayton Pierce Glynn, do a lot of this sort of work, and they could see they were getting all of these delay cases, so they could see that there was something fundamentally wrong with the system, or so it seemed. It wasn't just odd cases where something had gone wrong, and I have to say I thought much the same, so I've just done so many of these cases. So we thought that we needed to challenge the system itself, but it was quite difficult to do that. We did try and fail on previous occasions, and essentially what happened is that we'd often include an Equality Act damages claim or Human Rights Act damages, depending on the situation. And so then typically a generous offer would be made to settle the claim that obviously the client was absolutely delighted with as a destitute asylum seeker, and so the whole thing would just go away. But what happened on this occasion was that a charity made a referral for about 20 individuals, all experiencing these serious delays. And so a pre-action letter was written on behalf of all 20. And then the issues were resolved in the vast majority of cases, but there were still 4 that we had to issue for. And so those 4 became the claimants in the DMA case. And then, I mean, probably won't surprise those of you who do claimant work to know that the Secretary of State fought pretty toughly to, at that point, have the claim knocked out as academic. So once interim relief had been granted, to then say that it was all over. But essentially, and I'll come back to this, partly because there was compelling evidence of a systemic problem, the court was persuaded that, well, either that the claim wasn't academic, but in any event that the zoo life exceptions were met. And then just by way of background, this claim was joined with another claim called AA, which was concerned with a very seriously disabled failed asylum seeker and the particularly lengthy delays that he had experienced in being provided with suitably adapted accommodation under Section 4. So I'm going to just summarise the decision in 2 parts. Part 1 is not about systemic challenges, but I need to cover it so that the rest makes sense. Effectively, we challenged the decisions for all 4 of our claimants in the sense of the delay in providing the accommodation. And you can see the delays range from 6 weeks to about 6 months for our clients, and declarations were granted in all 4 cases that period of time exceeded what was a reasonable period of time to provide the accommodation. And the court looked at what it was accepted that inherent in Section 4 is a duty to provide the accommodation within a reasonable time period. So really the dispute was about, well, what is a reasonable time period? And the court accepted that in this context, it was a very short period, given the imminent prospect of conditions which breach Article 4. And it's clear from the Limbuela case that there's an obligation to act prospectively to avoid a breach of Article 3. You can't wait until the breach has happened and then try and do something about it. You've got to prevent it from happening in the first place. So that's the background then to the systemic part of the challenge. The systemic challenge was along these lines. A declaration was granted that Article 3 had been breached for the failure to monitor properly the provision of Section 4 accommodation. And similarly, there was a breach of the public sector equality duty for failing to have proper monitoring of the provision of accommodation to those with disabilities. And you can see I put a quote there which shows the court was pretty convinced that where a system is unlawful, it's entirely appropriate indeed required for the court to grapple with that. So in a nutshell, why was the failure to monitor unlawful? Well, as I've said, Section 4 requires accommodation to be provided within a reasonable time frame. And the problem is that without monitoring of the time in which this accommodation is being provided by private providers, there's no way for the Secretary of State to know whether she is complying with that obligation. And that was in the context of, and I quote, evidence of a real risk of a breach of the Secretary of State's statutory duty, i.e. to provide the accommodation within a reasonable time in a significant number of cases. And interestingly, the court set out in quite a lot of detail what proper monitoring as a minimum would require. So in terms of evidence then, we relied on the following. Obviously, we had the evidence from the 4 claimants' cases, and the 5th if you include AA, so they were used rather like case studies. We also had a really detailed witness statement from my instructing solicitor and also various well-respected charities in the sector, which outlined their experience on the ground of delays. We also had various parliamentary reports and some statistics from the National Audit Office, although actually there was then a whole debate about whether they were admissible. And as it happened, the court never resolved that debate. I think the judge felt that he had enough evidence of systemic unlawfulness without having to resort to that evidence. But crucially, and this is really what I want to talk about, it's pretty clear from the judgment that those elements of evidence alone probably wouldn't have been enough for us to show systemic unlawfulness. It was and I've underlined the relevant bit, the system-wide figures provided by the Secretary of State, which were key because they showed how the system as a whole was operating rather than, which I suppose was inevitable from our evidence, this sort of rather bite-sized ad hoc presentation of how the system was working. So how did we get that evidence from the Secretary of State? Well, it was a complete nightmare. Very early on, we had sought disclosure of the relevant contract between the Secretary of State and the private accommodation providers, which eventually was shared with us. And we also asked for the monitoring data on the timescales within which the accommodation was being provided. But we were told that the Secretary of State didn't hold that sort of data. But when we looked at the contracts, when they came through, we saw that there was a requirement under the contract for certain monitoring under what was called Key Performance Indicator 2 to be carried out. So we repeatedly requested that data and just didn't get anywhere with it. But insofar as we got responses, we were told that the data wasn't relevant to the claim. And also that it would be disproportionate. So we ended up making an application for specific disclosure, at which the defendant was given short shrift by the judge. So we got an order for the relevant information. There were then all sorts of further shenanigans, believe it or not, having to chase the information, and the way we'd agreed that a fair summary could be provided because of the commercial confidentiality considerations, but the fair summary that we got just didn't make any sense. It just wasn't explained what the various data meant. So we then had to make a Part 18 request to get explanation as to what this information meant. And when we finally got the data, it was not great by any means, but it was questionable whether it was bad enough, the situation was bad enough for there to actually be a systemic problem. And that indeed was the Secretary of State's case, and that there'd been teething problems, but it was all getting sorted out. However, at the beginning of the substantive hearing, it began with the Secretary of State saying that that data was inaccurate and had been disclosed in error. And so eventually, I think on day 3 of the hearing, this data here on the slide was disclosed. And importantly, this correct data showed a materially worse position on the ground, so much worse delays than the initial data had shown. And you can see I've highlighted in yellow the worst bits. And I don't know if you can see my mouse, but this 64%, the judge was particularly concerned about that, because effectively that showed that in that region, and this is, you know, after the teething problems would have settled down in January to March, there were delays in 36% of cases. And as the judge said, context is crucial. These represent delays of unspecified length in provision of accommodation to those who faced an imminent prospect of serious suffering caused or materially aggravated by denial of shelter, food, or the most basic necessities of life. And so really, based on that data in that table, the judge was persuaded that there weren't just delays in some cases, there were systemic delays. And then in terms of the evidence that showed the monitoring was inadequate, really there were 2 aspects to this. First of all, the judge was really concerned that the Secretary of State had initially disclosed the wrong data, but the system for monitoring was so inadequate that she hadn't realised that data was wrong. So that in itself, that error and how it came about, was said to be demonstrative of inadequate monitoring. But also the timescales, the only timescales that were being monitored were those under the contract, and the timescales that were specified in the contract weren't the same as the timescales that applied to the Section 4 duty and the avoidance of Article 3. And so really, until you can see there was a mismatch between the legal obligation and what was actually being monitored. So that's the whistle-stop tour of DMA, and I just note that it's not necessarily the end of the story, because well, the judge himself identified that there may still be other failings in the system. But just to end, in terms of lessons learned from this case, I thought the following were worth mentioning. The first thing is that it is really helpful to have multiple claimants, partly because it makes it harder for the challenge to be picked off and settled, but also because it is genuinely helpful for the court to have some in-depth case studies of how a problem arose in particular cases, particularly if there are slight differences on the ground as to how the problem affected different people. Also really important to have evidence from people on the ground with knowledge of the problem, well-respected individuals from charities and so on. Now, clearly, you need enough evidence and of sufficient quality for it to be relatively convincing, but I'd suggest that you do need to think quite carefully about quantity here, because hundreds and hundreds and hundreds of statements aren't probably going to be very helpful anyway, because the court is going to get bored, they're not going to read them all. So you need enough to show that you've kind of satisfied that area of evidence, but not so much that it becomes disproportionate and overwhelming, particularly because inevitably, and I'll come on to this, as I said, without some kind of further evidence from the defendant, typically, of how the system works, the evidence from charities and so on will always be said to be a kind of snapshot that inevitably can't encompass the whole of the system. But nonetheless, we got permission effectively just with evidence from those 2 bullet points. So given the low arguability threshold, it may well be enough for permission purposes. But really, I would suggest, certainly in a case like ours, if you're going to succeed, you are going to need some sort of broader systemic evidence of the system as a whole, which realistically only the defendant is going to hold. So you need to think very carefully about what disclosure you can request if it's not given to you automatically, and how you can use the duty of candour to your advantage. And if, like with us, you don't get very far, you need to be prepared to back that up with an application to court for disclosure. And I would just say you can't just use it as a fishing expedition. You need to be very specific as to why the information you're requesting is directly relevant to the issues in dispute in your matter. And if the answer is that the decision maker doesn't hold that information, well, in light of DMA, you might want to think about whether that in itself is lawful, particularly if you've got a PSED challenge, for example. Is that lack of monitoring lawful? And then finally, consider a Part 18 request if the information disclosed is unclear. I think I've gone over my time a little bit, Steve, so it might be best to just go on to the next speaker, and I'm happy to pick up questions at the end. Up to you.
Thanks, Catherine. Well, there's a number of questions I think that come together that I'd really like to ask you now, because they do go into, they're on the theme of process. I don't think they're specific to the evidence issue. I think you've given us a really excellent analysis of what claimants need to do in terms of establishing the evidential basis for a finding of systemic unlawfulness. But there's a number of questions about how we should approach the situation where you have individual cases that suggest systemic unlawfulness, but each time you try and bring a challenge to that individual, the defendant settles. Which is rather like, I think, what was happening in your DMA case. But the example that's given is local authorities, as we know, frequently will do that as well. And in order to salvage the policy, it certainly appears that there's an approach of just conceding individual cases. You have any thoughts about how to deal with that approach, and in practical terms, how you would still be able to get at the potential systemic unlawfulness?
Yeah, I mean, I don't think there's an easy answer. It's really difficult. Definitely having multiple claimants helps, because it's just harder to pick them off one by one. And I think, I suppose also what your claimant's objective is, because I mean, frankly, the claimants in our case may well have taken damages, even very low damages, just given their really extreme vulnerability. But there are other claimants who might decide that that's just not the point of the litigation, and they're much more concerned about fixing the problem and the system more broadly. And I suppose also just be prepared to make these arguments to the court that even though the claim is technically academic, it's appropriate for the court to hear it. And that actually comes back to this point about evidence, because if you've got some compelling evidence to show the court that on the face of it there really is a serious systemic challenge, then they're much more likely to waive it through on that basis. But if it all looks pretty dodgy early on, and you're kind of scrabbling around trying to get it together, then they probably will say, you know, no, sorry, this is academic, nothing to see here, not appropriate. Yeah.
Completely agree. And on that point, I'm in the Court of Appeal next month against Jack Anderson from Chambers, where the issue is whether a challenge to Devon County Council's approach to amending education, health and care plans, which was held by the High Court judge to become academic because plans were issued for the claimants, whether the High Court judge was entitled to reach that conclusion, or whether he should have gone on to determine the claim for the reasons that we were arguing. So we'll get some guidance, hopefully, from the Court of Appeal fairly soon about the approach to academic claims. There's an awful lot of first instance authority that goes both ways on when those cases should be allowed to proceed or not. Thanks very much, Catherine. We'll come back. I think there are already some other interesting process type questions in the Q&A. Please do ask anything else, or including on the guidance that Catherine's given on evidence as well. But I'm now going to bring in my colleague Jack Holborn to speak specifically about remedies. Jack, if you wouldn't mind making an appearance. Thank you very much. And I'll pass over to you for the talk about remedies.
Hi. So I'm just making the, here we go. Sure, you can you see my slides? Can I check, Steve?
Not yet, Jack. We can see you and hear you, which is a very good start, but we can't see your slides, I'm afraid.
Okay, well, let me just make sure that's working now. Right.
That looks promising. We've gone black.
That looks promising.
Yeah, there we go.
There we go. Right. So I'm going to talk about two different cases. One is JCWI and President of UTIAC, and the other one is DA and others, and such as State for the Home Department, which is actually, I'm only going to talk about the interim relief stage because the case is ongoing. I'm involved in both, was involved in both. Just as an aside, I think the JCWI case highlights one of the ways to deal with the risk of your challenge becoming academic, which is, of course, is who brings the claim. You can find a claimant, Joint Council for the Welfare of Immigrants brought this particular claim, challenging practice direction and guidance in relation to the issued by the President of Tribunals and the President of UTIAC. And as we'll come on to, and they, of course, had standing to bring their challenge to the lawfulness of those things. But any individual litigant complaining about the outcome of their appeals, these related to appeals in the upper tribunal, would have struggled. They would have had to go to, it would have been said they had an alternative remedy, which was to appeal to the Court of Appeal. And of course, that is sometimes, in some circumstances, another way of getting the same answer. As an individual litigant, if you want an answer, maybe there's another route, either an appeal or potentially a Part 7 claim for damages, by which you can achieve the same result, i.e. the court looking at the system and the particular legal problem that you've identified. Starting with the JCWI case. The challenge was twofold. First was to a pilot practice direction, which applied to all chambers of the upper tribunal. And the practice direction said, as I've quoted there, where a chamber's procedure rules allow decisions to be made without a hearing, decisions should usually be made in this way, providing this is in accordance with the overriding objective, the party's ECHR rights and the chamber's procedure rules. The second part of the challenge was to guidance issued in respect of this practice direction, issued by the President of the Upper Tribunal Immigration and Asylum Chamber. This practice direction and guidance was issued in response to the COVID-19 pandemic, effectively to try and get more cases determined without an oral hearing, so they'd be determined on paper to reduce contact time, which was particularly important in the early stages of the pandemic when people were not so au fait with video links and video meetings like these. Now, what the claimants suggested was that each of these created an unlawful presumption that there should be no oral hearing. They said it was the practice of UTIAC, as they were looking at in particular, to have had oral hearings since before it was UTIAC, or all the way back to the 1980s and 70s. And to make such a change, they said, required either primary or secondary legislation. By secondary legislation, they meant at least a change of the rules, not just of the practice direction, and certainly not by guidance. They also challenged the lawfulness of the guidance, which set out various factors as to whether or not there should be an oral hearing. And this included the importance to the parties. And by the time of the final hearing, hundreds of appeals had been heard without a hearing by the UTIAC under Rule 34. So what happened? The court refused permission to challenge the practice direction. What it said is that no presumption was created because there was a proviso of the overriding objective. It said usually you should have without a hearing subject to the overriding objective. but the claim against the guidance succeeded. The guidance was worded was slightly different, didn't in fact fully reflect the practice direction word for word in certain respects, in certain paragraphs. And the judge found, it was Fordham J, found it communicated an overall paper norm that was inconsistent with the overriding objective and common law principles of procedural fairness. The guidance also wrongly suggested that the importance of the case required the case to be more important than the norm. All cases in UTAC are, or almost all cases in UTAC are of significant importance to the individual litigant. And the guidance communicated that judges should not consider the run-of-the-mill case to justify an oral hearing just because it was important, because all cases in UTAC were important. But that didn't quite reflect the common law position. It also unlawfully admitted important factors as to whether or not there should or should not be an oral hearing. That's what was found. Now, the point of this section is to look at the remedies. Now, in both these cases, the claimants actually thought quite carefully about the remedies and got much of what they wanted with a few tweaks, but I think it's illustrative because remedies are very difficult in systemic cases. In an individual case, it may be obvious. You quash the decision maker remakes it. It's pretty easy in most cases, not all. In systemic cases, the remedies may be very varied and different, and there's a much higher chance that a claimant will want to seek mandatory orders. Now, I come at this as a defendant lawyer than a claimant lawyer, but it's very noticeable how much claimants have thought about their remedies, and I think this makes a big difference to how far you get, because ultimately a judge is looking to a certain degree practically at the outcome. What is the claimant going to achieve by the litigation is always going to be an important factor in the judge's deliberations. So, JCWI, what were the remedies here? Well, the relevant paragraphs of the guidance note were withdrawn. That was actually done by agreement. And that's important to note, that wasn't necessarily a given because there were parts of the guidance that were potentially interdependent. And certainly in the practice direction, if the practice direction challenge had been allowed to continue, there would have been serious issues. At the time the practice direction was challenged, the defendant was the senior president of tribunals, the Lord Chancellor, and the president of UTAC. However, the withdrawal of the relevant paragraph of the practice direction would have affected all chambers of the tribunal who were not all represented, and it was slightly unclear how that would impact upon subsequent paragraphs of the practice direction and, of course, the guidance. As it happened, it was, as I say, there was an easy solution here, which was it was agreed that relevant paragraphs of the guidance note were withdrawn. But in all policy challenges, one has to consider very carefully about, well, what is the effect of excising that bit of the offending unlawful piece of policy from a wider document, say. The second remedy was that the judgment and the order were to be published on the judiciary website, which was also not controversial. The issue really, though, was what to do about all the individual cases that were affected by this ruling. Now, publishing a judgment and order on a website might be good enough for lawyers, but for individual litigants, it's unlikely to come to their notice. Now, in our case, the tribunal could write to the individuals, but bearing in mind that they may not have the relevant addresses, particularly as their legal advisors, if their appeal had been dismissed, their legal advisors may no longer be on the record, may not have addresses for them. They are migrants who, if they've lost their appeals, may have been removed from the UK or perhaps more likely certainly moved on from whatever accommodation they were in. And so there were potential practical problems as to informing the litigants of the outcome of the litigation, which led to quite a bit of discussion. Obviously, the person who could most easily help was the Secretary of State of the Home Department, but the Home Office weren't a defendant to the proceedings, so they could be asked to assist, but they couldn't be compelled by the judge there and then. There was also issues as to what the content of communications were. And these were satisfactorily resolved effectively by the claimants organisation, JCWI, writing a letter explaining, highlighting the judgment, and it was agreed that the upper tribunal would send that information out, and JCWI set up a hotline to assist. However, questions on opening individual cases and how it affected individual cases was entirely left to UTIAC and the Court of Appeal. The claimants didn't ask for the court to interfere with individual cases, and nor do I think the court would have ever agreed to that. Above all, because there was an alternative lawful process by which individual litigants could then use the judgment and argue if they considered their appeal heard without an oral hearing was unfair. So next case was DA and others, which is, let's say, ongoing. This is a challenge to the lawfulness of the asylum screening process, in particular since the start of the pandemic. The particular concern giving rise to this is that migrants who travel through Libya may be victims of modern slavery. And it's alleged that potential victims of trafficking and modern slavery, PVOTs, are not being identified or were not being identified during asylum screening. And the result of this is alleged is unlawful detention, because as a general rule, not as an absolute one, asylum migrants will not be detained pending consideration of a claim of trafficking and modern slavery. And there will be a delay of a period of reflection before those claims are finally determined. And so if they are, as in these migrants' cases, were to arrive on a small boat across the English Channel, get screened, if they are identified as a potential victim of trafficking or modern slavery, they will be released while those claims are considered. If they are not, then they may be, certainly last year, before we left the European Union, they may be sent back to the European country in which they first claimed asylum under the Dublin III regulations. That was the regime until the end of last year. What had happened because of the pandemic to try and reduce contact time was that questions for certain of these migrants at screening interviews were curtailed. And most importantly, they were not asked about their journeys to the UK. Now, the published policy said they would be asked about their journeys to the UK. This change of practice hadn't been published. Now, the claimants sought interim relief, which was one, that the asylum screening interviews be carried out in full with all questions, including the journey question, as in published policy being asked. Secondly, that transit through Libya be treated as an indicator of potential slavery, modern slavery, which, dependent on how you read that, might have had the effect of meaning that everybody who travelled through Libya was a potential victim of trafficking in modern slavery, and therefore would have to have that potential claim considered before they could be removed. Obviously, it would have quite a significant impact on the ability of the Secretary of State to remove people under the Dublin III regulations prior to their full asylum claim being considered. The third thing they wanted was for referral to the SCA, Serious Crime Agency, if anybody was suspected to be a victim of slavery. And this reflects what is in fact in place in law for the referral of people who are potential victims of trafficking in modern slavery. They are referred to be considered, for their case to be considered in full, and then they're interviewed and evidence is collected and the like. Now, in the event, as interim relief, the court granted two bits of relief. Firstly, just two of the additional questions would be asked, but importantly, this included the journey question. Effectively, this was simply an exercise in narrowing down what was at the heart of the claimant's case, the claimant's complaints. And the claimant's case related to the failure to ask questions that related to trafficking in modern slavery. And so the court said, okay, well, we're going to order that questions relating to trafficking in modern slavery are going to be asked. It wasn't interested in other questions that weren't being asked, being asked in future. It was therefore very interested in the practical outcomes, even though there were other questions in asylum screening interviews not being asked, which the published policy stated would be asked. The second thing that was ordered was that the Secretary of State would take steps to confirm that she was satisfied that those conducting the screening interviews were aware of the risk to migrants and the risk of being forced into to migrants of being forced into modern slavery in Libya, and the test for a referral under the national referral mechanism, so that their claims of trafficking and modern slavery could be considered. So it was left to the Secretary of State to decide how that would be delivered. So I think there's a few lessons to be learned about remedies here. Firstly, think about the practical consequences in advance. I think the claimants in both these cases had clearly done some thinking about this, but even then, there were certain things that were perhaps not practical, or things that they hadn't thought of. A lot of thinking needs to go into what remedies you're seeking. It's one thing to identify the problem, it's another thing to identify the solution, and the solution that the court can deliver. In this respect, mandatory orders are likely to be as limited as practically possible. They're not going to, they're unlikely to order a party to do things unless it's essential, and also it's essential for the welfare, for the reasons that are at the heart of the given case. In DA and others, the court was not interested particularly in ordering, nor were the claimants, in ordering the Secretary of State to ask questions that were unrelated to the issues under challenge. It will generally be assumed that the defendant will act lawfully in future. So in the JCWI case, it must be assumed that the court system, the tribunal system and the Court of Appeal will deal with individual cases, and they will do so in a lawful manner, taking into account the judgment and of course considering matters for themselves and seeing how that affected individual cases. So there will always be limits on how much relief you can obtain, and it will be assumed that if the defendant can deal with it themselves, it may well be assumed that they will do so. They will do so properly. I think a few practical things. Non-parties can't be compelled to act unless you bring them in as another party. You've got to be prepared for further submissions after the initial judgment. That was an approach in JCWI. I think you need to be clear about what relief you're seeking. Just saying further and other relief may get you into trouble. And of course, it gets you into trouble, perhaps most of all, when it comes to costs. And for that, you've got to think about and Croydon. The court will be very interested to look at, have you achieved the remedy sought when it's considering questions of costs. So I think that just about covers it, but any questions?
Thanks very much, Jack. I'm just looking if anything's come in. I don't think there's anything specific on remedies. I think you've covered very helpfully those remedy-related questions. Could I be cheeky and just put another process point to you that's coming on the Q&A, though, which is an interesting question about time limits, which I touched on as well. And the suggestion or the question is, if you've got a situation where the 3-month outside time limit has well gone, does it start again if a policy is reviewed and the elements that you were concerned about previously remain, in your view? So can you get another shot at it if the public authority reviews the position and reiterates the position that they took before?
I mean, I think there's a big depends there, but not necessarily. But there is a big depends. I mean, what's the process? Is the review a statutory review? If a statutory review is being carried out, then I think undoubtedly you can have another look at what is going on. Has perhaps not a statutory review, but is there some kind of legitimate expectation in respect of the review? I mean, I'm thinking about certain policies that are ongoing. The personal injury discount rate, for example. There may well be promises made or statutory provision. I can't remember what it is for personal injury discount rate, but there are regular reviews. And one suspects that if it was said that the formal review of the personal injury discount rate was unlawful, someone would be able to bring judicial review and it wouldn't be considered out of time because matters are changing. If on the other hand, you're trying to trigger an ad hoc review because you don't like an existing policy, I think you're going to struggle.
I agree, Jack, entirely. Yeah, and the only thing I'd just add to that is from someone who generally practices for claimants, keeping very much in mind the clearer approach I think the courts are taking, a more rigorous approach to the question of when the grounds of claim first arose, and the guidance we get from cases like Badmus in the Court of Appeal, the prison case, that what really matters is when would a policy have first been relevant to you. So, for example, in Badmus, it was when you first went to prison. It wasn't when the specific policy applied to you, but it was when it was capable of being applied to you. That was when your, quotes, 3 months, of course we know it's properly, and in any event 3 months, started to run. And that's really quite harsh in some ways, because you might not have known it was potentially going to apply to you. And of course, that's relevant to the court's discretion to extend time. But that now seems to be a clearer approach. So we can't just rely on ongoing, well, this policy is just ongoing and we can challenge it essentially whenever we like. So I've certainly started taking a more rigorous approach recently to those limitation issues in the light of the guidance in Badmus and other cases. And I agree entirely, you can't just confect a review. But if you do manage to achieve a review and they change the policy in some way, then at least it's arguable, I suppose, your grounds of claim have only just arisen, isn't it? So you're sort of in the lap of the gods as to whether you get a change, in which case you might be back in time. But yeah, I couldn't agree more with what you said at the beginning, which is it depends. These are very, very fact-sensitive issues, aren't they? And keep us all very busy on both sides of the debate. There is a question of remedies. What would you say, Jack, to how to approach remedies following a successful systemic challenge, where the problem's either a practice or the interaction between different elements of a system, but it's hard to isolate one specific unlawful bit of guidance? So could you get more than just a fairly generic declaration of unlawfulness? And also, sorry, slightly multi-part question, but what about making sure the public authority actually implements the terms of the judgment? Can you get relief that's going to help ensure implementation?
Yeah, I think there are two examples in there. One, on the first element, when you can't really pin down a direct problem. I mean, the DA and others case, which, I mean, it was interim relief, but actually, in reality, that bit of it about Libya guidance, about caseworkers understanding the tests for and the risk in respect of Libya, the test for referral, that was very similar. There was no, the claimants couldn't identify a piece of guidance or particular issue. The problem they identified was they had clients who had turned up to asylum screening interviews, not being asked a journey question, and then subsequently been detained and then raised issues of trafficking before they were removed. And they said, well, look, if we'd been asked the journey question, we would have said everything about Libya. And they also raised queries as to whether or not the caseworkers really understood the risk in Libya. And the solution the court found was to ask the Secretary of State to satisfy herself. Now, I think that is the kind of thing that you might do if there is an unlawful approach, but you can't pin down what the problem is. Well, you say, well, look, defendant, you go away and you satisfy yourself. And now that doesn't mean you're absolutely bound if there's a mistake in future, but you may be required to report to the other side as to what's gone on, which then in turn brings you to the second question: how do you monitor that? Well, the court may be willing to allow you to monitor that. You can obviously, there is inherent liberty to apply. But you, of course, may also have a specific liberty to apply. So in JCWI, there was a question mark as to communications, and that wasn't fully resolved in the judgment, even though the judgment was delayed for some discussions. And so, indeed, exactly what happened was there was communications correspondence explaining what happened, and the ability to apply to the court if there was need for intervention.
I find that really interesting, Jack. I mean, what I take from that answer is actually the approach is rather more sophisticated than you might think if you just read the textbooks. That increasingly, perhaps, would you agree? He said, asking a leading question. That increasingly the court is willing to engage in rather more sophisticated debates about what relief should be, and it's not just mandamus or certiorari. It's that you can actually have quite nuanced relief.
I should say there's one small other point you should be aware of, that both the cases I'm referring to were decisions by Fordham J.
Yeah, well, that
probably
depends on new judge.
At the forefront, a new judge, and at the forefront of obviously public law development, one would suspect.
Very helpful caveat, Jack. Thank you. Thanks very much. So we've now covered up between us the legal test, the kind of evidence that you might need, and the remedies. And I'm now very pleased to bring in Carla Clarke, and Carla's the head of strategic litigation at Child Poverty Action Group. And there's two reasons why I'm particularly pleased that we've got Carla joining us this afternoon. First of all, CPAG as an organisation has been at the forefront of this kind of strategic litigation, systemic challenges. And in fact, the only person who was prepared to answer the question at the ALBA launch for the latest edition of Mr. Justice Fordham's book referenced the CPAG, one of the CPAG challenges as their example of systemic strategic litigation. So that's the first reason. The second reason is that Carla herself has been involved in lots of successful recent systemic challenges in the welfare benefits context. And so I'm really pleased that we've got the opportunity to hear from you and to learn from your experience, Carla. I'll hand over to you. Thanks very much.
Thanks for that introduction, Steve. Let me get the sharing going. So as Steve said, I work for a Child Poverty Action Group, and as well as working on child poverty policy issues and having a reputation in welfare rights advice and provision, we take on a small number of test cases each year. So, you know, legal team is 1-2 solicitors. So of its nature, number of cases are small, and therefore of their nature, they are strategic in terms of they're not about assisting the individual in a very particularized situation, but, you know, we're taking on cases which are, we know, affect the individual, but also those in a similar situation to them. So of their nature, they're systemic challenges. But that said, when Steve invited me to take part in this webinar, I asked him, are you sure you want me to? Because we don't get involved in systemic unfairness challenges. And, you know, he was, as he said in his introduction, you know, the concept of systemic can be broad. So yes, you know, come in, bring your experience and bring your points of view to the discussion, Carla. And actually, it's been a useful process for me in terms of looking at the cases that both Steve and Katherine referred to, looking at those and how systemic unfairness has almost become this term of art within judicial circles. So we have systemic unfairness where you've got a legal duty, so your Section 4 accommodation provision duty that Katherine was talking about, or your Section 42 education health provision duty that Steve was talking about. So you've got a legal duty set out in the legislation, and then the state has discretion, or, you know, different policy choices as how that they actually fulfill that duty, and the possibility that the specific policy choice they go for risks the unfairness in terms of that duty not being met. So that's the arena in which systemic unfairness has come to be used by the courts. Within the welfare benefits field, there's hardly any room left for any discretion or policy choices. You know, the field is just so highly regulated at a legislative level. So the legislation doesn't just set out, you know, what are the eligibility criteria for a benefit, or what is the rate at which the benefit will be paid. You know, the legislation, you know, goes into, well, how it will be paid, when it will be paid. So with UC, you know, transfers to people to people's banks, and it's going to be within 7 days, over a 7-day period, etc. So it's all highly legislated. And in some ways, a lot of the policy choices have already been made, and then they're put into legislation. But even in that situation, is there an arena for systemic unfairness? But let me talk you through a case that we were involved in last year. And you can see that there's still very much systemic unfairness in terms of the common understanding of the word, not the judicial term of art. So let's take a situation. You've got 2 women who are care workers. They're both care workers. They both work 16 hours a week, at national living wage, so 16 hours a week earning £8.72 an hour. They're both lone parents. They have, several children each. It's either 2 or 3 children each, and they have housing costs. And the combination of what they're entitled to, what their children are entitled to, and the housing costs mean that within universal credit, because they're having to pay benefits to supplement their low wages, the total amount of their benefits is over the limit for the benefit cap, which outside of London is £1,667 a month. In London, it's 1917 to reflect higher housing costs in London. We can see very quickly that housing costs is very easy for a family with several children to be taken over the cap limit. But the benefit cap, as we know, is there to incentivize work. So one of the ways of getting off the benefit cap, or one of the exceptions to the benefit cap, is if you're in work. And under what is called legacy benefits, so the benefits that universal credit is replacing, the exception to the benefit cap was if you were receiving working tax credit. And if you were a lone parent, you qualified for working tax credit if you're working 16 hours a week at national living wage. So these two women, these two care workers, both of them working 16 hours at national living wage, they would be in receipt of working tax credit and therefore exempt from the benefit cap. But they in fact happen to be claiming universal credit. And as a result of that, the exception in universal credit is slightly different. In universal credit, the way it works is fundamental to the design of universal credit is something called the monthly assessment period, and your needs as well as the income that you're receiving in that monthly assessment period is what then determines how much universal credit you're entitled to. So you've got this monthly assessment period, which is integral to the nature of universal credit, and also integral to universal credit for those who are working, who are employed workers, is something called the real-time information feed from your employer. So when your employer pays you, they send in a return to HMRC, an automated process, and DWP itself extracts information from that real-time information feed as to your earnings. So within UC, the combination of the importance of this monthly assessment period and this real-time information feed means that the exception to the benefit cap is not just that you work 16 hours at national living wage, but rather that you earn the equivalent of 16 hours at national living wage, but calculated as a monthly amount. So 16 hours, you're earning 16 hours at national living wage times 52 to make it an annual amount, and then dividing it by 12 to make it a monthly amount. Okay, so we've got our two care workers, both working 16 hours at national living wage, both just receive total benefits above the benefit cap level. One of them is monthly paid, so great. She earns £604 a month, and so she qualifies for the earnings exception, and she's not benefit capped. The other lady is paid 4 weekly. So if she's paid 4 weekly, in each monthly assessment period, she's just treated as only having worked those 28 days, even though she'll have worked a full 30 or 31, how many other days in a month. She's treated, she only receives pay for 28 days, which means that she only earns £558. So she doesn't hit the £604 needed to be exempt from the cap, and so she's capped. The potentiality that her benefits are reduced by £400 up to 20% of her earnings. So I think anybody listening to that situation, two women doing the same work, same amount of pay, same hours, just one happens to be paid by their employer four weekly, the other happens to be paid monthly. Most ordinary people would talk about that being inherently unfair, about it being arbitrary. But the problem is that provision, that policy choice about how we determine who's exempt from the benefit cap, that policy choice has already been put into legislation. It's not about there's a legislative provision that there's going to be exemption from benefit cap and there's a policy choice that fulfills that legislative provision. And there's a range of policy choices available. In fact, the policy choice has already been put into the legislation. And so it becomes, well, actually, that inherent unfairness, that systemic unfairness, which is going to hit all people who are working, you know, for an employer who pays 4 weekly rather than monthly, that systemic unfairness, which is there contained in the legislation, how do you challenge that? And the way at CPAG, the way that, you know, we've brought cases is, you know, in some ways, well, are we talking about discrimination here? Are we not Equality Act discrimination, but are we talking about Article 14 discrimination? You know, an example that I was giving, to all intents and purposes, those two women, those two care workers, trying to put enough food on the table, they're in the same situation. Yes, they're everything about their situation is the same, apart from how their employer chooses to pay them. And so potentiality of an Article 14 discrimination challenge, and, you know, it is a possibility, and they are ones that we have run, but some that we, you know, people who are alive to HRA challenges is, you know, the issue of the pushback from the government. So, you know, status is always up for grabs. Even ambit becomes up for grabs. The whole justification, and so although discrimination could be a possibility, you know, it's not the way the courts has necessarily started going in these cases. The other way of bringing the challenge to the legislation itself would be, well, you know, is it breach of the Padfield principle? You know, the Parent Act, in this situation, the Welfare Reform Act, you know, has a specific, you know, policy and objective in relation to universal credit and ensuring what pays. Is a discretion available to the Secretary of State in terms of introduction of secondary legislation? Is the way that she's, you know, the secondary legislative choices she's made, do they breach the objective of the Parent Act or frustrate the policy? The slight problem there is sometimes the legislation itself for the general group of people might work, and it's only in certain situations, you know, for certain cohorts that it's not working. So in that situation, the Padfield principle wouldn't get you home. And what we found, and Steve will be very much alive to this in terms of the Johnson case that I think he referred to in the introduction, is what the courts have been going down, the path they've been going down, and this has happened in 3 cases now, is, sorry, I realised I wasn't looking at my slides at all, is irrationality. And so those are the 3 cases in which the courts have decided to assess the Secretary of State for Work and Pensions secondary legislative choices by reference to irrationality. And what they've spoken about is the framework they've set out for this rationality, for the irrationality challenge, is whether a reasonable balance has been struck by the Secretary of State in terms of when she's brought forward these, you know, put the policy choice into regulations and decided not to provide for these situations which are inherently unfair, whether she struck a reasonable balance in not providing for those situations. So it's whether, in determining whether that reasonable balance has been struck, the criteria that the court, or the steps that the court have applied, are set out here. This is taken from Johnson, which is the first case on that previous slide, so a Court of Appeal decision last year. What are the disadvantages of deciding not to fine-tune the regulations to deal with the unfairness? Yes, so what are the disadvantages of the claimant? You know, what's the impact of the unfairness on the claimants? And then what are the disadvantages of adopting a solution to unfairness? Yeah, so what's the impact on the Secretary of State in terms of having to try and come up with a solution? So you can see these 2 things in the balance, you know, the impact on the claimants and the impact on Secretary of State in terms of addressing the problem. And then also to bring into that balance is, would a solution be consistent with the overall nature of the regime? And then so ultimately you weigh those things in the balance And then you ask yourself, has a reasonable balance been struck by the Secretary of State in deciding that the advantages of adopting a solution outweigh the disadvantages of not doing so? And that analysis in Johnson was applied in a subsequent case of Pantellerisco, from which the illustration I gave you about these two women working 16 hours at national living wage, Pantellerisco was about that. It was about people being, as a mother, being benefit capped in this situation purely because she was paid for weekly. And in that case, it's quite stark what the judge was asking. The question to be addressed is whether the decision of the Secretary of State as to the drafting of the regulations was outside the range of reasonable decisions open to decision maker. I just let you to think about that for a little bit, because it is, if I take you back to that first slide that I wasn't sitting on, sort of there, the idea that the scales of justice, sort of weighted against the ordinary individual. And then you get this particular question that's being asked. And it's quite, to me, it's bold of the courts to be asking that. It's something fully endorse. But when you look at it in just black and white, it's sort of the reverse of the cases that Steve and Catherine and Jack have been talking about. It's not that, well, there's legislation, this is what Parliament said. How are you going about implementing that legislation and your policy choices? But rather, there's this policy choice which has led to the drafting of regulations, which then have been approved by Parliament. But we, the court, are going to say, well, actually, is there an inherent unfairness in there amounting to irrationality? So that's where we are with this concept of systemic unfairness, which doesn't fit into the developed jurisprudence around this term of art, but very much sits in ordinary people's understanding of a situation which is unfair to a wider group of people than just one individual. And then just to tie that in with a couple of things that were said by Catherine and then with Jack. So Catherine was talking in terms of the types of cases she's been involved in and the evidence there. And I would very much endorse what she said in relation to the types of challenges that we bring at CPAG, is that usually we work with multiple claimants. So in the Johnson case there, the top one there, we had 3 claimants. So we had 3 claimants, and there's another claimant. We had 2 cases joined together. Lead A were acting for Johnson, and CPAG were acting for 3 individuals called Woods, Barrett, and Stewart. And having the 3 I took on multiple claimants for the very reason that if people's life circumstances are difficult, and especially people on benefits, people fall away, things become too much for them. So having a range of clients, ensures that at least 1 or 2 of them will stay for the long haul, as these cases usually are. And then also it allows the court to see the variety of situations in which people are being impacted. So, would very much endorse what Catherine said in relation to that. And then Jack was talking about remedies, and that's been a real issue for us in these cases, is that the remedy is getting the legislation amended. Yes, addressing that unfairness that's contained in the legislation itself. And yes, that creates problems in terms of what happens to people who've already been affected if the legislation isn't going to be retrospective. And the unwillingness of the courts to get involved in terms of directing any sense of time frame for amending legislation to be brought forward, because of course, it's not within the power of the Secretary of State to actually dictate the parliamentary timetable. So the very restrictive nature of any mandamus or mandatory order, as Jack was saying. So Steve, I think that's me.
Thanks, Carla. That's extremely helpful. Can I just pick one point up? I think I'm right in saying that all these cases that you've cited on the slide here are challenges to secondary legislation. Is that right? They're all challenges to regulations, aren't they?
Yeah.
And that obviously allows us, those
Yes.
who are active with the claimants, to bring quite a wide range of challenges, actually, including irrationality challenges, as we've done successfully in those cases, you say. Have you ever had to challenge primary legislation? Are any of the welfare benefits mischiefs, if you like, actually in the primary legislation, or is it always secondary legislation that you're able to go after?
We've had the primary legislation challenges, which is the big ones, which are rather than smaller bits of the universal credit puzzle, which are the broad policy ones, so benefit cap and two-child rule, which yes, because it's a challenge to primary legislation, the only avenue open to us is a Human Rights Act challenge, which then has the whole difficulties of status and pushback on how wide status can be, but also quite convoluted jurisprudence in terms of what is justification, what the test is for justification, what exactly has to be justified. Is it the although the jurisprudence is quite clear in terms of what has to be justified, there's that in terms of the actual application of that to the facts of the case, it's not always clear that what is being said is being done is actually what is being done.
Well, that comes back to Catherine's very excellent talk on evidence, doesn't it? With all these points to link up, of course. That's really helpful, Carla. Thank you. Can I just encourage Jack and Catherine to come back on screen, and we'll just take any final questions for the last few minutes that remain. I have got one here that's probably first of all targeted at Catherine, but obviously colleagues, please chip in, which is a question about evidence again. So what would you do where the evidence is the absence of provision? And the example that's given is post-16 provision for autistic young people. Can case studies of individuals who don't actually get provision amount to sufficient evidence, Catherine, in the first instance?
Well, I think it really depends on the specific challenge, but I think the case studies are certainly helpful, but they're unlikely to be enough. I'm talking about for a kind of pure system challenge here. So I think what you would need are some sort of statistics on the absence of that provision across a local authority's area or nation, or across the county, or whoever it is your defendant is. So so absolutely absence. I mean, in a way, that was like in the DMA case, it was the absence of accommodation that we were referring to. But the point is that you need a evidentially neat way of, understanding and presenting to the court how that absence manifests and how widespread it is.
Carla, do you want to add anything on evidence issues and how you would go about evidencing the systemic flaws with the regulations in the kinds of cases that you bring, and showing the court that they aren't just unfortunate hard cases which the court shouldn't therefore condemn the whole system for, which is always a risk, I know.
I was thinking about this when I was listening to Catherine speaking, and I was thinking, hey, we've got away with it slightly lightly. And I think partly because it just speaks for itself that you don't think there can only be one person who works, who's paid for weekly rather than monthly. But what we have usually done, and so in the Johnson case, which was about this situation where, again, the integration of the monthly assessment period and this real-time information feed is that sometimes people who are on regular monthly pay might occasionally receive 2 monthly pay packets in one assessment period, because the assessment period is different from the calendar month. It's not January to February, etc. So occasionally when people are paid early to avoid being paid on a non-banking day, for example, they'd receive 2 monthly pay packets in one assessment period, and therefore, their income from alternative means other than benefits is taken as being higher, and so their universal credit amount would then drop. And in that case, as well as the very compelling evidence from the individuals themselves as to just how the impact of this oscillating benefit amount, alongside very stable monthly wages, the evidence of that, including one of my clients, who'd just been so distraught that there'd been a couple of suicide attempts. So those are compelling evidence, alongside evidence from CAB in relation to just how people on benefits. There's there's no surplus to pick up any oscillating wages. So as with Catherine, evidence from reputable charitable source, but also in our ones we've had a payroll expert along who's given evidence to show frequency of pay cycles. So in Johnson case she provided evidence in terms of monthly frequency of monthly pay cycles, but also when people were likely to be paid paid towards the end of the month or not. The idea of evidence about the frequency whereby people were paid early to avoid being paid on a non-banking day. And then in the Pantarisco case about the 4-weekly paid lady who's subject to the benefit cap, she provided evidence there about 4-weekly pay. But I think one of the problems that we've been finding, Steve, is that the response of the Secretary of State to our types of challenges, which were within universal credit, is ultimately, oh, well, this is how the universal credit computer system has been designed. And it's just going to be so costly for us to rectify this. And that becomes really difficult for us to, well, how do you challenge that? Yes, sort of, we can look at the legislation and we can look at situations where there are already some exceptions or there was some discretion applied, or where some situations where manual calculations have to be done, so it's not all automated. So we can put those, but without knowing actually the UC tech design, it's quite difficult for us to challenge statements. Well, actually, to deal with this would require a total calculation rebuild, and that would cost at least 7.5 million. And we were very lucky in Johnson that you got, Lady Justice Rose, who said, well, with all due respect, if you've got such a sophisticated computer system, I don't think it cannot be the case that you can't find a solution. But that is one of the problems in this area, is when you're dealing with digital issues and you're having general statements thrown at you by Secretary of State or put in evidence of the inability to come back on that with something substantive. So yeah.
That's really helpful, Carla, thank you. What I take listening to that, and what I remember as well from Johnson and other cases we've been involved in, is that you absolutely have to put together the evidence in the best way you can, and adding in statistical evidence from relevant experts, case studies, etc. We pull it all together. But at the end of the day, I do wonder if ultimately you kind of know whether you're going to win or not based on how it feels. And Johnson just felt wrong from the very beginning, hugely wrong. And Lady Justice Rose's judgment vindicated that entirely. And as you say, she was prepared to say to the Secretary of State, I said, essentially, I'm not impressed or not interested in the cost of remedying this. It's just grossly wrong and needs to be put right. And that is a robust approach for the Court of Appeal to have taken, a unanimous Court of Appeal, of course.
The other thing I feel I should say, because I'm just slightly worried everyone's going to think you always need loads of statistics now, which is not what I meant. I mean, it really does depend, I know it's obvious, but on your case and what you're challenging. And a bit like what Steve says, it depends on the nature of the problem. There'll be some problems that are so egregious and obvious that you're not going to need evidence. It's a bit like indirect discrimination challenges. I mean, there's now actually authority that says this. You don't necessarily need statistics to show a disproportionate impact, but it's going to depend on the nature of the complaint. And similarly with policy challenges, RW is quite an interesting one, the no recourse to public funds challenge. We relied on that in DMA. I mean, there the court effectively just relied on the wording of the policy. The court was satisfied that it was just kind of obvious from looking at that wording. So actually evidence, and there was also a very compelling example for the child who was the claimant in that case. But sometimes the wording in Carla's cases of maybe the legislation alone or the policy will be sufficient. So sorry, I'm not saying you always need loads of statistics.
Absolutely, yeah. Jack, can we? Yeah, let's come to you and any thoughts on evidence.
I was just going to. On statistics, JCWI, there was a lot of time spent on statistics, but in the end, it didn't really come to much. I mean, there were some basic facts that were required, such as there were a lot of cases affected, and the claimant certainly had a go at showing they suggested a lower success rate of not all hearing cases. But in reality, that's not what got them home was the wording, and it very much turned on that. And I think in Johnson, having worked on the defendant's side in Johnson, You know, a lot of effort was spent on statistics and working out how much it was going to cost and that kind of thing, and ultimately it came down to the fear, in that case, the feel of the case. So statistics can help you; they can get you over that sort of prima facie evidential hurdle to show there's a problem, but I don't usually think they get you home on the legality.
I'll mute myself to say I entirely agree, Jack. And I'm really pleased that we've ended the talk looking at the way you prove or disprove these kinds of cases, because it plays very much into my firm view that you win or lose judicial reviews on the facts rather than on the niceties of the particular legal test. So let's move away from my bit at the beginning, where we dance on pinheads about precise wording on tests, and focus on what we spent a lot of the talk talking about, which is how you evidence systemic unfairness or illegality or irrationality. And one perhaps sort of last thought to leave with people is, are those questions beginning to coalesce as well? Is there much of a difference? You know, could you have decided Johnson, for example, applying a fairness kind of approach? So there's an interesting one there, but we haven't got time, I'm afraid, to go into any more issues. Thanks ever so much, everyone, for the excellent questions tonight. And thank you very much to everyone who's spoken as well, and in particular Carla for coming and joining us and giving a really useful insight into how CPAG litigates these cases. As mentioned, the recording of this event will be on our website shortly, and there'll be many other opportunities to see each other virtually during the pandemic as well, I'm sure, as part of the 3906 webinar series. Thanks everyone, and have a good evening.